or if you end up not giving enough, examples in support of your invention, there's it's liable to come under attack for insufficiency. There's no basis for this claim you've made.
I would just take back to that blade example which you gave. So, doesn't the prior art relate to that example there when you talk about the hole or that?
Yeah, yeah, yeah,
Yes,
sure. I mean, there was lots of prior art that
yes,
spoke about placing holes on the lower blade
yes,
so that what in the art that it's called debris, hair debris,
yes.
so that hair debris can wash away.
Okay,
The placement of holes is I mean, the holes on the lower blade very well known, but this feature where you shift the hole so that half of it is exposed, half of it remains covered, not known prior to the date of his patent,
okay, yes, exactly.
which is I think 1991 or 92 years.
Okay, okay,
Yeah,
okay. And that means the claim part, if you go to the claims section in
mm.
drafting a patent, before going to the next question, I would just also like to have your inputs that I've been told that yes, drafting, and in drafting the claims part is also the most important. If we
Right,
talk about specifications or the complete specification, so the
right.
claims part also becomes most important while drafting. So what is your take on that?
Absolutely, absolutely. Ultimately, what you get in a patent,
Yes,
that boundary that you get,
yes,
is defined by the claims. And so the mantra that we use when we are teaching our juniors, or when, the way we were taught, is imagine that for every extra word that you put into the claim,
yes.
your client has to pay 1 crore rupees. Imagine that.
God. Oh my God.
So just imagine in your mind when you're drafting, every extra word that you put in is going to cost you that much.
So can you please help explain how? How?
Sure.
Yes,
So, for example, I mean, it doesn't actually cost you that much, but
yes,
it's
but
to train your mind that
yes,
just less is more. See, in claims, less is always more. And what do I mean by that? Now, let's take that pen example again.
yes,
You've invented the rubber grip. Now, there are so many ways in which one can define that claim, right? So, for example, you could say, I have a circular uh, rubber sleeve for a pen. I'm going very specific now because this is exactly what you have done. If this is your claim, there are 20 ways to break it, right? You said rubber, I'll use some other material, I'll use some sort of an elastomeric plastic, right? You said circular in your claim, I'll use maybe I'll use a slightly oval shape, but I'll make it compressible, wo kaam wohi karega, right? You said pen, that means it's not for pencils and for the other writing implements, right? So some of those words you put into your claim completely unnecessary. You had you said, for example, an elastomeric material uh, for a writing implement, or why the function of an elastomeric material uh, shaped, having a circumference such that the inner diameter of the circumference or the inner surface, it's hollow, and it's the hollow surface is capable of receiving a writing implement. And then in your dependent claims, you can say wherein the material is rubber, wherein the shape is round. You can add all of that in the dependent claims. You can even add extra features and say wherein the outer surface has certain grooves so that the grip is even better, but not in your main claim. So the less you put into your main claim, your independent claim, the broader the protection. So let me give you another example. Suppose your claim was, I claim A plus B plus C plus D. That's your claim. And I make an infringing product and I use A, B, C. I don't use D, right? Do I infringe? No, because In order to infringe, I have to have all A, B, C, and D.
All four in place.
And D is one extra word in your claim.
Okay.
One extra word in your claim is that extra feature that your claim needs. I don't have it, I'm out.
So it sounds very, very interesting that the less you put, the more you get.
Less is more. In fact, there are times when clients will tell you, आपने इतना छोटा ही claim बनाया. वो हमारे दूसरे केस में तो 1 पेज लंबा क्लेम बना था, 1.5 पेज लंबा क्लेम बना था. And I wanted to tell him that claim is useless because you put so much in there that you made it like a cakewalk for any infringer to bypass that patent.
That's why it's very, very tricky game. It's a mind game, I guess. The whole business of patents, GI, trademarks, be it any. We are focusing today on patents basically. And I guess how do you look this patent litigation or patenting process or everything in today's scenario in post-COVID or in line with Corona now? What is going on in the patent world as of now?
So there's a lot going on. There's a lot going on.
Yes.
There are, when it comes to testing kits,
Yes.
and when you're using DNA-based testing kits, and you use those, there are some underlying patents. Some of those patents have been filed in India. So how do you launch a kit without infringing those? There are some issues around that. There's a lot going on around that. There are issues around remdesivir. Remdesivir actually enjoys patent protection in India. And then there was this whole debate about, should the Indian government revoke? Should the Indian government issue compulsory licenses and all of that? But thankfully, the patentee smartly went ahead and issued really, really nice low-cost licenses to a lot of Indian manufacturers so that the drug is in the market. There's so much happening in terms of, in terms of PPE kits, in terms of masks, in terms of, even dispensers for sanitizers on certain surfaces that are antibacterial. Lots of innovation going on in that space. But I think your question also is a little broader in terms of, when it comes to litigation,
Yes.
what are the things to kind of watch out for? Again, I want to tie it into what we discussed earlier in terms of prosecution, that good prosecution bad prosecution will impact your patent litigation. And there is a doctrine known as the doctrine of prosecution history estoppel.
Okay.
Now, what that means basically is that, and there's a very famous UK case on this, forget the citation, but the principle there was claims are not elastic. Okay. So you can't go to the patent office and before the patent office say, no, I only want so small protection. All that prior art is, very different. I'm only asking for this very specific small thing. And the minute you come out of the patent office, you suddenly say, no, my claim is so big. It's not such a small claim. It covers this also. It covers that also. That's what the whole notion that claims are not elastic. Scope has to be the same. So therein comes in the principle of prosecution history estoppel. Now, if at the patent office, you gave up certain things in your claim, you narrowed it down, or when you were responding to the patent office, you kind of made a statement saying, my invention is, really useful for this, and it is, this is the main feature of my invention. You make those kind of statements. Then tomorrow, those statements can actually be used against you when you go to enforce your patent.
Okay.
So keeping an eye on what you say during prosecution is important. The other thing that I feel that the link between prosecution and litigation is, again, this is kind of a unique requirement to India, where we have this restriction, not a restriction, like this obligation on every patentee that when he files a patent application, he has to keep the Indian Patent Office informed of every application that he has filed in any other country. And it's called a Section 8.
Yes.
Section 8 requirement. And lots of cases before the Delhi High Court also where interim relief has not been granted because there was no compliance with Section 8. Now, one is, of course, keeping the Patent Office informed of where else you have filed this case. Second is Section 8(2), which says if the Patent Office asks you, give me search and examination reports, and you don't give all the search and examination reports, then you have violated Section 8(2) as well. And the first, and to my mind, the only confirmed revocation of a patent in India on the ground of non-compliance with Section 8 was a case that I had argued before the IPAB in 2012. This was a Tata Chemical versus Hindustan Unilever case, where I was for Tata Chemicals, and in our view, Hindustan Unilever had suppressed certain information before the Indian Patent Office. There was a negative examination report where internationally the claims were held to be not novel, not inventive. The controller at the Indian Patent Office is in the examination report raised that objection saying, give me all search and examination reports. The patentee writes back saying there are no search and examination reports. Patent moves to grant. So we argued that this is clear suppression because the Indian Patent Office did not have access to those prior documents that were cited in another jurisdiction.
Okay.
Had they seen it, perhaps this patent would not have been granted. So that patent was revoked on the ground of non-compliance with Section 8. And then, there's the famous Kempira decision of the Delhi High Court. There's the Phillips, Major Bail versus Phillips case of the Delhi High Court, which also says that, look, non-compliance, if it has a material effect on that patent, there's a good chance that we'll revoke it, and interim relief, then you kind of can forget. So, Nandan, my point really is that, prosecution, sometimes we take it casually, but ultimately, if we want to build a high quality, really good patent, a good patent portfolio, then we must make sure that, things are aligned, that we prosecute it in a good way, we get high quality patents so that they're easier to litigate and enforce also.
So basically what I take that the search of which you are talking about in your previous case, that means the search is basically, it comes within the forte of the patentee.
Right.
It is on who yes.
So when you file a patent,
yes,
where you would, and Shoolini University would have filed these forms,
yes.
It's called the Form 3. And actually that Form 3 is an undertaking. You are submitting an undertaking to the Patent Office saying that I will keep you informed of where else I file this patent application, what is the status of those applications, and if the Patent Office asks me for search and examination reports, I will of course provide those search and examination reports. Okay. You provide that undertaking.
Yeah.
Right? Okay. So that's my point, that as a patentee, for example, yes, it could be argued that, all of this is available online and, the examiner and controller can access all of this online. Yes. Just because I didn't submit one examination report, that doesn't mean my patent becomes bad. No, you see, and I mean, in a way, we are moving towards that. India has now kind of, we are members of the WIPO case, which is a CASE, which is the Access to Search and Examination. I'm not sure of the full form. And therefore, these systems are coming in. But ask yourself, as an examiner of the Patent Office, are you able to search easily at the Korean or Japanese Patent Office? Or the Chinese Patent Office? You're not. And sometimes even the USPTO, it's not very easy here. So they are saying that, look, this system was there, it was introduced in 1970 as a means to make the working of the Indian Patent Office better, reduce the load on the examiners. We were a young patenting society, so to reduce the load on the examiner, these provisions were there. And therefore, if a controller is asking you, you submit it.
So, what is then the role of your, in between in this case particularly, what role becomes like a company of yours here in this part?
I'm sorry, I didn't follow the question.
I mean, as a facilitator between the Indian Patent Office and the inventors. So this is also the role of your company, I guess. The companies like yours.
So we always advise our clients, especially our overseas clients, that when the examination report is issued, please let us know. And actually, our team will, in any case, go online and check. And we will see that, okay, look, it seems you filed it in these 10 countries. Have you filed it in any other country? If so, give us those details. You see, sometimes things are not published. And it may so happen, or you may have actually filed a divisional of that case in some other jurisdiction where it was refused. All of this becomes relevant, no, to the Indian Patent Office. If they see it, they may want to look at it before issuing a grant. So therefore, we play the role of ensuring that this compliance is done. We also, regularly send reminders on that.
Okay, so just a small question. Some of the viewers here can be a law students also. Can you just explain in such a scenario what is the priority date now here then? Well, in simple words, what is priority date?
What is priority date?
Yes.
Priority date is the date on which you first filed the patent application anywhere in the world. The starting point is your priority date. Now, it could be a provisional. Okay. It could be a complete. And that priority date serves as the basis for all your future filings in other countries also. So why is it important? Suppose, Nandan, today Shoolini University files a patent today in India. July 21st, 2020, you file a patent. Now, it takes you 6 days. Say you want to also file this in the US. So you'll reach out to either an Indian agent and you'll ask him, hey, can you help me file this there? Or if you know someone in the US whom you trust, you'll reach out to that guy and you will ask him, can you help me file this patent in the US? Now, it'll take some time. Maybe it'll take you a week. Maybe it'll take you 2 months. I don't know. But it will not be on July 21st, 2020. Right? Therefore, the fact that when the US exam officer will look at your file, he'll say, hang on, you filed this here in December 2020, but there is a prior filing of July 2020 in India. Therefore, what you are filing today is not new. Right? There, the issue of you get the benefit as if you have only filed within 1 year of filing in India, you get the benefit of a priority date. If you didn't have that priority date, all your prior filings can be used against you. And it becomes worse if, say, as a university, you had, or as an applicant, you file it today. Tomorrow morning, somebody in your marketing team makes a disclosure. Yeah. And it goes into the public domain. And then you file in the US. The US, that publication will work against you.
And yes, and say if I file a patent today, right? And n number of people, ABC also might have filed today or might be few hours later than me. Right. Who gets that patent?
Well, if it's the same date, yes. That situation has not strictly happened. But okay, assuming hypothetically it happens, it's on the very same date, then the chances of both the claims being identical are also very slim. Okay. Right? Now, let us assume even that happens, that you file and I file on the same day, and we both file identical claims. Then, yeah, to my mind, either you've got it from me or I've got it from you. Right? Okay. Then the case of wrongful obtaining comes in. There's a provision in the Act.
Wrongful obtaining, yes.
Then we'll be fighting with each other a bit. But as far as the Patent Office is concerned, they will actually either get one of you to amend the claim so that you're both not claiming the same subject matter. Okay. Or the fact that you have two identical claims on the same day, the potentially who filed first in terms of hours may also matter. Okay. Right? Because I'm prior to you. If I file at 10 in the morning, you file at 9 in the evening, I may succeed.
Okay. So that means timing, hours and everything is relevant.
It is relevant, which is why they used to always give a timestamp. Now, of course, it's digital.
Okay.
But the olden days, when the stamp used to come, they used to also put a signature and a time.
Time, okay. So may I just know your thoughts on the constitutional validity? Now we have heard a lot on the constitutional validity of Section 3D
Hmm.
of the and the patentable inventions, and we have the famous landmark cases also by the apex court.
Right.
So any discussion debates a few years back, they were not happening without discussing the constitutional validity of the Section 3D.
Hmm.
So what's your take on that?
See, I don't see. I mean, the issue of whether or not it's a constitutional challenge to that section that has kind of been decided, right? So, India is within its right. We've not violated our international obligations by setting a certain threshold for inventions. And I mean, where did 3D really come in here? 3D came in to prevent what was referred to as evergreening,
Evergreen, yes.
right? So you file, a pharmaceutical company files a patent today, uh, and then 2 years, 3 years later, they make a small change or polymorph of that existing molecule, and they file another patent. So you keep extending the scope or the term of that patent. So it was to check that we introduced 3D, and we said, look, we just a new form or just like the mere new use of a known substance by itself, we're just going to raise our inventive step standard a bit, and we're not going to give patents to that. And that's actually helped the Indian pharmaceutical industry a fair bit.
Yes.
Now, yeah, and I mean, in all fairness, I think if you study the Novartis decision clearly, it's a very reasoned decision. I think there's basis in saying and refusing that patent.
Exactly. So okay, just your last take now. What is your advice to the new inventors? How do they research? How do they move on ahead with the patent office? Any of your strategy here, your core mantra to our inventors?
I would say, please spend a little time and effort in doing your own prior art searches. It's not that difficult. Uh, there are lots of free tools. There's Google Patents, the eSpaceNet of the European Patent Office. There are some paid databases also, but I think Google Patents, eSpaceNet, these are great starting points. And at least Google Patents is like a Boolean search, right? So you can type in your keywords, see, read a few patents, and then you'll say what I'm calling a shaft, somebody else is calling a rod. So then you will kind of go back and refine your search terms, but spend that little bit of time and clearly see that in your mind you should be clear that look, yeah, this is all known, but where my invention really lies is this feature. The minute you get that clarity in your mind that look, this particular feature is not taught in any of the prior arts, then when you have your discussion with your counsel or your attorney, you'll be able to guide your counsel much better and say that look, actually, I've seen these features are known, but this feature I feel is where the uniqueness lies. It helps you get a more focused and a stronger patent ultimately, as opposed to you just sending an invention disclosure and after 6 to 8 weeks you're getting a search report where the guy says, hey, listen, all of this is known, and then you as an inventor get irritated and say, Arey yaar, this guy doesn't understand, but he's not seen that this feature is not there. So you wasted a few months here. You may as well have gone with the stronger invention disclosure
Yeah.
and take the quality game up. That's the only thing that comes to mind right now.
Okay. And one thought for the budding lawyers also, law students who would be watching. So how do you see the IP industry today for the law students here?
Well, I've always seen it as a most fascinating space, and especially when it comes to patent law, because if you enjoy technology, if you like to see what's happening, the latest stuff that's happening, it's fantastic because the to my mind at least, a patent lawyer is a bridge between the technical community uh, and the legal community, right? So he really serves as a multi-purpose bridge. He's able to take the language of the scientists, understand the tech, and then he uses his legal and patent skills and serves as a bridge for the patent office and the courts. So it's really, I mean, patent attorneys play a fantastic role. It's a very exciting and challenging role, but you do need I would say, some interest in science, and uh, preferably, if you have a technical degree as a basis, that's great.
Okay, so I guess yes, it was very very informative, educative. We could touch few of the well-known facts about the patents with all the intricacies in between. Thank you very much, Mr. Essenese Obhan, for giving your valuable time.
Thanks, Nandan. Thank you for having me. I'm. It's we're actually not too far away as we speak, but hopefully, when things are better, we can meet up, and I'd be happy to come and meet, and maybe meet students in class and discuss this further, or even get into the intricacies of claims if you like. And thank you for having me.
Thank you so much. Thank you.
Okay, bye.